Hi, everyone. Welcome to our final unit on contracts law. Thank you for being so patient as we spent 3 weeks on this intense unit of understanding how contracts are formed, contract damages. And in this final unit, I want to introduce you to actually 3 topics, but I'm only going to make a PowerPoint on one of them. That's the Uniform Commercial Code. And then we will use the discussion board to discuss the liability of accountants. But I wanted to make this PowerPoint to highlight a few differences between what we've already learned about with contract law and the Uniform Commercial Code. This harkens back to something I mentioned at the very beginning of this whole contracts unit, which is that we have different sources of law for governing contracts law. What we've been studying so far is really the foundation, and that is the common law. And you'll remember from the very beginning of the semester that the common law is the development of law through court cases. There isn't a statute or a piece of legislation that says this is what an offer is, this is what an acceptance is. We have developed understanding the formation of contracts and contracts damages largely through court cases. But one of the challenges facing courts and businesses with that way of developing contracts law is that it can lead to differences among the 50 states, and it can make contracting and businessing, the contracting of business, more difficult. So that is why scholars developed the Uniform Commercial Code. So you might be wondering, where's the legislature in all of this? And the legislatures really took a backseat to the development of the Uniform Commercial Code by legal scholars who got together and said, listen, we need businesses from Massachusetts to be able to contract with businesses from Maine, and we need the laws between these states and all 50 states for that matter to be uniform, meaning relatively the same, and that way there is predictability for businesses. Because if every state was starting to develop laws that were very different from each other in the laws of contracting, we would not be able to so smoothly buy and sell products across state lines, which you all know from using the internet all the time, we do every day. So we need to have some common rules as to contract law. So instead of turning to Congress and saying, you need to pass laws pertaining to all these aspects of contracting, the scholars got together and drafted the Uniform Commercial Code, which are now widely adopted by the individual states, since this is really an area of state law. And what the Uniform Commercial Code did, in effect, was to modernize contract law and just make it easier for businesses to conduct that business through contracting. That was really the point. So the Uniform Commercial Code is pro-contract and pro-business. The Uniform Commercial Code, as a way of applying law, does not seek to find, this is an awkward thing to say, but doesn't try to make a no contract situation. In fact, in any areas of dispute, the court looks for a contract to be formed, because usually that was the intention of the parties. So what I'm going to try to highlight in this PowerPoint are just some of the key differences between the common law and when that applies and the Uniform Commercial Code. The one thing I'd like you to do on your own is, it's actually in your book, or you can even Google it. Look at the sections of the Uniform Commercial Code, because it doesn't apply to everybody. And that's probably why many of you have not heard of it before, and yet you go into the store and you buy things all the time, or maybe you sell your car to your friend. The Uniform Commercial Code does not always apply. So that's often the first point of analysis for a court in any sort of contract dispute, is to try to figure out, in this contract dispute between these parties, are we looking at the common law, which is what we've discussed so far, or do we apply the Uniform Commercial Code? And if so, which section of the code applies? In this PowerPoint, I'm going to focus exclusively on Article 2 of the Uniform Commercial Code, which applies solely to the sale of goods. So again, take a look at the other sections that are in the UCC. We're certainly not going to have time to dive into all of them, but just so you know, like the one on negotiable instruments, for example, I do want you to at least read that chapter, even though I'm not going to make a PowerPoint about it. Those are the laws that pertain to negotiable instruments only. So here we're going to focus just on sales of goods, which is Article 2. So I know we've already discussed in our understanding of the statute of frauds and how the writing only applies to sales of goods over $500. We're going to come back and talk about that some more. Article 2 of the Uniform Commercial Code is the section of the UCC that applies solely to the sale of goods. It does not apply to any services. So what is a good? A good is any movable item that we can hold, touch, feel, like I'm holding a pen. The pen is a good. I use a picture here of furniture. Furniture is a good. You can pick it up and move it. What's not a good? The building where that furniture is located. That we call real estate. The structure of the building is the real estate. So a good way to kind of keep in the difference between goods and other items is to think about that concept of being movable. A good is the items in the home that are movable, whereas the structure of the home itself is not a good. That is the real estate. The other interesting piece here is notice it says sale of goods. So first, the UCC section Article 2 only applies if it's a good, but also only applies if it is a sale. So what does that mean? If I sell you my car, that is a permanent exchange of that item. That's what we mean by sale. We are permanently changing ownership from one entity to another. That means borrowing or lending an item that is not governed by Article 2, nor is leasing or renting. So if I am renting some equipment, if I'm renting furniture for my office instead of purchasing it, and I'm intending to return it at the end of the period, the Uniform Commercial Code Article 2 does not apply to that contract. That makes sense? So if I purchase furniture for my office, that is a sale of a good. And if there's a dispute about that sale and the terms of the sale, what money was owed, the court will apply the law from the Uniform Commercial Code. But if I'm renting my items, from Article 2, but if I'm renting my goods, then Article 2 does not apply. All right, hopefully that makes sense. Moving on. Obviously, one of the biggest challenges to figuring out, does the UCC apply? Remember, I just mentioned that, is what to do about contracts that are both a little bit of a good and a little bit of a services. We call that a mixed contract. What do we do then? Does the UCC apply or not apply? And here's where I want you to either pause the video, or if you haven't done it already, make a note to go back to your textbook and look at this really, I think, fun, interesting case that's called Rotner. It was a case involving the sale of software. Is software for your computer, is that a good or a service? I'll leave you guys to read the case to find out what that particular court said, but I think it's a really good modern example of the struggle that courts face just to find out if Article 2 of the Uniform Commercial Code even applies. All right, so we know it has to be a good, has to be a sale of the good. And next up, in terms of Article 2, is the concept of a merchant. So a merchant, to me, when I hear merchant, I feel like I think of like old time men involved in commercial transactions. But we still use the word merchant in modern times when we apply the Uniform Commercial Code. And the reason we use merchant is because we hold merchants, and I say we, I mean the court system when they do contract interpretation and contract disputes, the court holds merchants to a higher standard than it does people like I would describe me. I'm not a merchant. A merchant, according to the courts, is somebody that either has a specialized skill in a certain area or is trained in that area, routinely deals in that area. We hold that person, that entity, to a higher standard. A really easy example would be me offering to sell you my car. I don't routinely buy and sell cars. I don't have any specialized skill or knowledge in that area, nor am I hiring a friend or someone that I know who is a car dealer to sell the car on my behalf. It's just lonely old me, Sugarman, selling my car. I am not a merchant. I might be selling a good, so I'm still under the UCC, but I'm not what they call a merchant. Who would be the merchant? The car dealer, the used car salesman, somebody who routinely deals in that area or has specialized skills. And those individuals are held to higher standards in the application of the UCC. Okay, so now that we understand a little bit about the sale of goods and the merchants, I want to talk about a couple of the other key differences with the Uniform Commercial Code. And you'll see it's all part of the same theme of the Uniform Commercial Code, which is to be pro-business and pro-contracting. The bottom line as we go through the next couple of slides is that it is actually easier to form a contract and to find that a contract has been formed if you are under the UCC. And that is because the UCC is much more flexible, or another way of saying it is that it is less rigid than the common law. When we learned about offer and acceptance and formation a couple of weeks ago, in the common law, if you have a contract that's outside of the UCC does not apply. The offer, the acceptance, the finding of mutual terms between those two parties is really strict. And if the offer and acceptance don't match, then the contract is just there. The court will find that no contract existed. That's not necessarily so with the Uniform Commercial Code. In fact, it could be that the parties haven't decided on all the details of their contract, and there will still be a contract. This is, again, I'm going to refer you to your book. Take a look at the example involving shrink wrap. You know what shrink wrap is? You buy something at the store. I don't have anything in front of me, but you buy a piece of technology, and you can read a little bit on the outside, and you buy it and you bring it home, and then you open up that shrink wrap around it, and then you read the additional terms and conditions. Take a look at that example. It's called Pro CD, and it's in your book. And it's a really good example of the flexibility that is applied to finding the existence of a contract under the UCC. And it really shows us how different a case like that would have been if it had not fallen under the UCC. So in terms of forming a contract, the offer and acceptance, much more flexible. Almost any words or something, even your behavior could indicate acceptance. So that makes the formation of a contract a lot easier to find. Again, pro-business, pro-contract. The statute of frauds still applies in the Uniform Commercial Code. So we don't get away from this whole provision of the sale of goods over $500. That should sound familiar. We've already mentioned that. I told you we'd be coming back to it, so here we are. There is still a writing requirement, just like there is in the common law. But again, the terms can be not as rigid. Still has to be signed by the defendant. Still should say the quantity. But let's say it doesn't say the price, just to use that as an example. The market price can be added. Under common law, if your statute of frauds was applying and you were missing the payment amount or the dollar amount, that would be fatal. The court would say this writing is not sufficient to satisfy the statute of frauds. But not so under the UCC. The court could add the market price at that time to find that the writing was sufficient and therefore uphold the contract. So that's just one way in which the courts show they're much more flexible in finding the existence of a contract. Last, but certainly not least, and your book devotes a couple of pages to this, so just take a look at some of the examples, is what happens for what we call additional terms. Now, you might be familiar with some contracts where your company has a form and so does the other company. We call this the battle of the forms. Which one is going to control? Which one, if I send my form to you and then you send your form to me, which one of those controls the situation? Again, here it's really interesting because the court will almost always find that the contract existed because we exchanged forms, but the terms that go into the form does depend on what the merchants said to each other. So take a look at some of those examples since I'm running out of time on the PowerPoint. I just want you to see how the court can find that the additional terms, when the additional terms apply and when they don't apply, when they're in that final contract. And I hope you see through this chapter how the Uniform Commercial Code really helps to make it easier for businesses to contract.